All right, so I think I got that all situated. Give me just a second, guys. I want to make sure that I am recording. All right, so I think. Okay, so. Oh. Mm. Okay, so now check that box. And I will go ahead and get up my chat. All right. So first off, can everyone see my screen? Perfect. All right. So I'm going to jump into our unit for tonight. It is just right out the gate, employment discrimination, because we can't hire our talent without knowing how to mitigate risk for our business. And so with that being said, just our learning objectives for this particular course is to adhere to employment discrimination laws and know their application. We're going to look at how to calculate adverse impacts. I pulled up a video that I really would like for us to watch if time allows, because I realized that a lot of times when I'm going through the course, it's the instructor that is speaking. And so you all are listening to it from an auditory perspective, but sometimes it helps to see just some other visuals. So I did find a YouTube video that kind of walks through how to calculate the adverse impact, and it has some animation to help kind of drive that point home, because calculating adverse impact, you may see that on your exam. That has been a piece of feedback that has been provided just in the past about having maybe like one or two questions that are specifically geared around adverse impacts, whether it's calculating it or just having an understanding of it. And then lastly, we'll define and explain the federal employment legislation. And so we'll get into that Title VII, the ADA, the ADEA, GINA, the I-9, all of that good stuff will be impacted into this presentation here. So it looks like Chris likes to pop in like questions on the forefront. And so with that being said, is this like just to get you all like up and running questions? Have you seen a question like this before from Chris, or how does he like to initiate these types of questions? Oh, just random pop quizzes. Okay. All right. So I did see his polls. They might be over here. So I did. So this particular question, I did not see embedded into his poll. So I wasn't for sure, but we can take a stab at it. He doesn't have them labeled A, B, C, or D. So this one, because I was reading through it and it talks about the EEOC and the right to sue, which we haven't covered just yet. So I didn't know if this was like a question to kind of get you all thinking about what the answer might be. And then we get into the section and then we discover what the answer should be. And then we rediscover this question again later on in the slide deck, because this question actually appears twice. Yes. So yeah, it's going to, so this question will appear again at the end of the section before we get into the next section, because you all get me twice. So you get me today, and then we will meet again on Thursday. So Chris is out of the office this week. So let's go ahead and we can talk through this one, because again, I don't see it wrapped in his poll questions that he has set up for me. So let's see here. So an employee files a complaint with the EEOC. So it should be EEOC, the Equal Opportunity Employment Commission. And so at the expiration of the review period, the employee receives a right to sue letter from the EEOC, and it informs their manager that they will be executing this right. The manager contacts you as the HR person because they are concerned that the EEOC just gave the employee what they need to win a case against your employer. What do you say to the manager? So what would you say to this particular manager? Would you select A, B, C, or D? And again, I know that they're not lettered, but we will assume that, we are going in alphabetical order here. So A, B, C, or D. Yep. And go ahead and pop your answer into the chat box. And you might want to write it down somewhere else as well, because we'll come back to this question, like I said, because I've seen it twice in his slide deck. So put it in there for safekeeping, and then write it down somewhere else. And then as we go through the presentation and we come across the EEOC and have a better understanding of it, we'll come back to this question and see how well you did. All right, so I'm going to go ahead and advance the slide now. Hopefully you've had some time to read through the question and make a decision on what your response is going to be. And if I can get my mouse to work here. So let's go ahead and get into our employment discrimination. And so I always like to say we don't know how until we have to, and I can't remember the exact way I phrase it, but we can't know where we're going until we know where we've been. So Melanie, you're already revising your answer. So let's learn a little bit more about how Title VII came about. And so it first started with Civil Rights Act of 1866. And so just so you all are aware, the equal opportunity is every one American's birthright. And I'm reading on page 2, verbatim, in that second paragraph, underneath the header of Civil Rights Act. And so the American dream is based on the belief that everybody can achieve success if they work hard to earn it. Success does not depend on being born into a privileged class. Unfortunately, many Americans have not had equal opportunities for employment. Instead, they have been unfairly treated and discriminated against because of their age, race, religion, sex, or disability. And so you're going to hear me say that probably for the next few slides or so. And so I kind of rattle it off pretty quickly, but just know that it's all encompassing that Title VII, the Civil Rights Act. And so with that being said, in the chat box, why don't you all tell me what you already know about the Civil Rights Act? So what do you already know when you hear the word Civil Rights Act? What comes to mind? That it's too general. All right, what else? So no one else has heard about Civil Rights Acts? Just Sharonda? So we're going to talk, yep. So Brooke says it's largely about racial discrimination. So there were, and you're right. So when we talk about Civil Rights Act, we talk about Title VII, it is to mitigate, right, discriminatory practices. Yes. And to increase equal employment for all. And so, some things that may come to mind is maybe the Montgomery bus boycott. Or if you recall, or if you remember the Civil Rights Act of 1866, just as a fun fact, if you didn't already know this, it was the first federal law to affirm that all U.S. citizens are equally protected under the law. Also defined citizenship and made it illegal to deny any person the rights of citizenship on the basis of race or color. And so just another key takeaway or another fun fact about the Civil Rights Act of 1866 is that it was an important step in the struggle for equality. So like it was mentioned in the chat, equal employment. Daniel says it passed in 1964. Yes, by LBJ, first law that prohibits discrimination for race, religion, and sex origin. The EEOC Commission was created along with the passing of the CRA. So Daniel is like getting way ahead of us. So that is absolutely true, though. But please remember that the Civil Rights Act of 1866 was the first initial step in the struggle for equality. Again, you're going to, and I shouldn't say again, but you may encounter some of these types of questions on your exam. And your exam likes to remember dates. And so it might ask you, what came out of the Civil Rights Act of 1866. And you want to remember that it was the first the first step in that struggle for equal rights. Or you might want to say something to the effect of, it was to affirm that all U.S. citizens are equally protected under the law. Now you're going to have a multiple choice and you're going to have to select the correct answer. But again, you just want to be mindful that your exam, it does like to call out specific dates with factual information tied to it. So let's go ahead and advance forward and let's get into section 1981. So we are 1981 as it relates to 1866. In section 1981, it is applicable to racial discrimination in employment relationships. And then section 1981 guarantees that all persons of the U.S. shall have the same rights in every state and territory to make and enforce contracts. That is important to know. So again, section 1981 guarantees that all persons, again, of the U.S. shall have the same rights in every state and territory to make and enforce contracts and to the full and equal benefits of all laws and protections as enjoyed by white persons. And so in section 1981, it continues to serve the legal basis for pressing some charges of discrimination, even though there are more recent civil rights acts because of other certain advantages. And so what I want you to remember about section 1981 is, again, that the same right in every state and territory to make and enforce contracts, but it did not protect against, or it failed to protect against voting rights, holding public office, social rights, and equal access to public accommodations. So again, we are advancing forward, but there's still some restrictions when we think about equality for all. Yes, Melanie, you're exact. So 1866, civil rights allowed all people the right to enter contracts. Yes, that is a really great call out there. And I really do want you all to remember that because just in feedback from other learners that has come up in previous exams. Not to say that it would be on your exam, but it has been a piece of feedback that has been provided to me. And so enforcement of section 1981 is not assigned to any federal agency, and individuals must file their claims directly in federal courts and must prove that the employer has engaged in intentional discrimination. And that's still true to today. And so as we are progressing, we get into Title VII of 1964. So now we are here, we have called up with Daniel's chat statement that he's placed in there for this evening. And so the Civil Rights Act, which was passed in 1964, the Title VII of this act prohibits discrimination in employment on the basis of race, color, religion, sex, or national origin. And then section 703, which is really important to call out, and it just states, and again, if you're following along in your book, I'm on page 4. It states in section 703 that it shall be unlawful employment practice for any employer to fail or refuse to hire or discharge an individual. And you can continue to read that excerpt there. And then also to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because, again, of such individuals' race, color, religion, sex, or national origin. So this particular act establish the EEOC, so that Equal Employment Opportunity Commission, and outline the procedures that the commission should follow to prevent unlawful employment practices. And so most states also have comprehensive fair employment practices laws, very similar to the EEOC. These laws have a significant influence on virtually all HR practices, especially recruitment and hiring of new employees, right? That's when we really have to make sure that our hiring managers are well equipped or well knowledgeable in asking certain questions in the interviewing process, right? So some of the key takeaways that I want you to take away from Title VII is that this law here, Title VII, it outlawed discrimination. It ended racial segregation and protected the voting rights of minorities and women. And then again, against race, religion, national origin, gender in the workplace, schools, public accommodations, and federally assisted programs. And so when we talk about Title VII, again, we're talking about discrimination, we're talking about equal employment. And so yes, and I forget that this one comes up in the slide now, and I usually talk about it a little bit later, but we can talk about it now. And so most recently, that Supreme Court ruling of last year, if you all were in the media or watching TV last year or conversing with your colleagues, you probably are aware that the Supreme Court ruling passed last year that Title VII now protects the basis of sex. That includes gay, lesbian, transgender persons, right? So it made it more of an equal employment opportunity for us to be more inclusive with all persons. Right, and so here is the Civil Rights Act of 1991. And so as you can see here now, we are looking at our discriminatory practices and how do we establish those. And so how do we provide proof? Who does the initiation? How do we fact find? So all of that is taking place underneath the Civil Rights Act of 1991. And so when charges of disparate impacts are argued in court, excuse me, the complaining party has the burden to show that a particular action is having a discriminatory effect. And so take note that the plaintiff must prove the prima facie evidence of discrimination. So prima facie just means on its face. And so, excuse me, you have to have enough facts, or you have to have sufficient evidence to raise a presumption before the other party has a chance to rebuttal. And so here are some of the key takeaways of the Civil Rights Act of 1991. It is the most complete civil rights legislation since the Civil Rights of 1964. Also, the ability to provide the injured parties with punitive and compensatory damages came out of the Civil Rights Act of 91. And then an employee can select trial by a jury rather than just the judge alone. And so those are just some key takeaways that came out of this act. And so now, oh, excuse me, I apologize. I went on mute because I had to cough and I did not want to cough on video. So let's take a look at particularity. So we know about shifting the burden of proof, right? We have to have that prima facie. We have to make sure that we do our fact finding. We have to present that information before the other party will have an opportunity to rebuttal. So particularity is when job applicants claim that the hiring process is discriminatory. Here they are required to identify which employment practice is causing the discrimination, such as culturally biased personnel tests, a prejudiced interviewer. Again, some of it is very direct, and some of particularity could be very indirect. So again, it is up for that person to be able to identify what employment practice or were they discriminated against. Foreign practices. So much like the Civil Rights Act of 91, there is the provision of the 91 Civil Rights Act that extends protection to U.S. citizens working for U.S. companies in foreign countries. Race norming. Here the law prohibits race norming, and that just refers to adjusting test scores, using different cutoff scores, or altering the results of employment-related tests on the basis of race, religion, sex, or national origin of test takers. And so you also have motivating factors. And so here, most charges of discrimination are not simple cases where an employer's actions are based on a single discriminatory motive. Most cases involve mixed motives. Such as where a female is passed up for promotion both because of inadequate performance and because her behavior does not fit a traditional stereotype. That's when we really get into like our own biases, right? So race norming, biases, prejudices, or motivating factors, would come into play here. And then you have your remedies. And so this is the most significant provision of the 1991 Civil Rights Act. And this is when that introduction to jury trials came into effect. And so, and without just being judged by the judge alone. So you could have a trial by a jury of your peers. And then it also talks about the compensatory and punitive damages. When you think about damages, and you have to think about the size of the employers. And so employers with 15 to 100 employees is 50,000. And then it kind of increases there again, depending upon the organization size. And here is a slide of the burden of proof. And so you'll see this slide also in your text on page 5. And you can see how it kind of goes back and forth. So remember, you have to be able to plead your case. You have to have that prima facie evidence. And then your employer would have the opportunity to rebuttal. And so as you can see, it kind of works its way down to a defendant wins and to a plaintiff wins, depending upon the evidence being presented, right? So we're going to talk about the 4/5 rule here in just a moment. So you can see from this example here, this worker brings complaints and must show prima facie evidence of discrimination. The company must show why the practice is justified by business necessity or a bona fide occupational qualifier. And so again, we'll talk about BFOQs as we progress into tonight's lesson as well. But just to say that this is the way we've always done it, or I'm not sure why we do it that way. If it hasn't been validated, if it's not reliable, then we're really going to have to justify the reason why we're doing what we do in process of recruitment. As you can see here, so the worker must show that the employer's practice is a pretext for discrimination, or there are equally good procedures that have a less discriminatory impact. So again, explaining the why. And then the employer can come back and refute the worker's claim, or the employees win. So again, this is where we talk about documentation, crossing our T's, dotting our I's, making sure that we have our ducks in a row when an employee does file a discriminatory charge, whether that is an employee or during the employment process. All right, so our first poll question of the evening, and I'll go ahead and get this launched here, And so it says the 1866 Civil Rights Act, Section 1981, guarantees that all citizens of the U.S. have equal rights to what? So go ahead and let me know your answer. And I'll give you all a few seconds to answer this question. All right. So it says the 1866 Civil Rights Act. Well, I'll end the poll. There we go. So the 1866 Civil Rights Act, Section 1981, guarantees that all citizens of the U.S. have equal rights to, and I see, so we're going to go in, again, alphabetical order, A through Z. So A is free and open expression of opinions, make and enforce contracts, hold a job, advance within an organization. So the correct answer here is B, as in boy, make and enforce contracts, which is really important. And that is what, again, that came out of that 1866 Civil Rights Act. It was the first act that we talked about opening up Unit 2 this evening. So keep that in mind as we progress through the other slides. So let's see here. I will stop sharing and we will move on. So as promised, I told you we would get to our BFOQs. And so here is the bona fide occupation qualification. This does permit discrimination on the basis of religion, sex, or national origin, only when these attributes are reasonably necessary for the operation of the business. And so an employer who discriminates on the basis of religion, sex, or national origin must be able to demonstrate that the attribute in question is a BFOQ necessary to the normal operation of that particular organization. If you can't, then again, it kind of goes back to a discriminatory practice. So as a general rule, the courts have been very reluctant to assign a BFOQ status for gender, customer preference, such as preferring a female flight attendant or female weight loss counselors, has not been judged to be a legitimate BFOQ. Only when privacy issues are the main concerns for customers have the courts accepted gender as a BFOQ. And even when there is no to be no reasonable alternative to excluding all of one gender from consideration of employment. So when do you all think it would be appropriate to have a BFOQ that is related to sex? In the chat box, tell me, when do you think it would be appropriate to have whether a male or a female attending to either a service being provided? Right, Ludovine says actor or actress. Yeah, absolutely, Brooke. So for a TV show, if they're casting certain characters, yes. So that's your BFOQ. That's when that would come into play. Melanie says changing rooms. So, so changing rooms as it relates to, so I'm trying to think, like when I go to, I don't know, like Old Navy or something, you can have a male or female in the changing area. Now, if they're going into the room themselves with the person, probably not. You probably, I don't, you know, you may not when you go into, I'm thinking like maybe Victoria's Secret and you're doing maybe a bra fitting, you probably would want a female to assist you. But just going into a normal, I would say, retail environment, you know, yeah, I think it could be male or female. So yes, social norms, and it may depend on the store. You're absolutely right, Melanie. So that's kind of like that slippery slope, right? When you're talking about a BFOQ in particular. Tamara says certain doctors. So again, we want to be very, very careful about what your preference is and the or looking at it from a discriminatory practice. Do you have to have male or female doctors specifically? So again, think about it. Brooke says maybe like a gym. There's only female employees in the gym's women's locker room. So yeah, so that would be another BFOQ, right? So absolutely, that would probably fit the description. If you were to make up a job description and you were searching for a locker room attendant, specifically a women's locker room attendant, you're probably going to be looking for a woman to fulfill that position. Again, they're really, when you think about BFOQs, it should really be difficult. We're not trying to make this easy. It should be very, very difficult for you to have a BFOQ. So again, actors, actresses, the locker rooms come into play a lot. If you think about nursing mothers, if you think about, I'm trying to come up with some other examples. I think those are the really only ones that really come to the top of my head immediately. But again, it should really be a tough question to answer. But very good. And so here you're looking at the disparate treatments and the disparate impacts. And so yes, that's another good one, Melanie. So yeah, when it comes down to religion, the church priests, yes. So that would be a BFOQ as well. So again, very difficult. They're very far and few between, trust me. Here is your disparate treatment versus your disparate impact. As you can see, there's some identical words, but they mean two totally different terms when you put on some additional verbiage there. So we have disparate on both sides, but we end with either treatments or impacts. And I don't want you all to get these two sides of the fence confused because they mean two totally different things. And so as you can see here, disparate treatment is intentional. It occurs when a person is treated differently because of that person's race, religion, sex, or national origin. And so you're going to have direct evidence of discrimination because it shows on its face an intent to discriminate. An examination called a cohort analysis involves a comparison of the treatments of similarly situated individuals or groups. And so if you think of this disparate treatments, and I always like to, I don't know, I have my examples come from call center experience. And so if you have an employee that has worked at a call center and they receive 3 bad reviews and then they're let go, that person could file a claim. What's going to happen is EEOC is going to look at how many other employees are terminated for that same exact reason. And if there were any derogatory remarks that were made, how often that race is either hired or fired. And so if you think about the EEOC, and you think about filing a claim of discrimination, everything is discoverable. So they're going to go back through your files to see how often you hired women, how often you termed women. Were there any other discriminatory practices that were used? We're going to go through files. Did they ever come to the HR office and complain about their counterparts or anything of that nature? So everything is going to be discoverable. And then they are going to, again, the prima facie. So you're going to have that opportunity to rebuttal, but it could come down to either the person winning or the business winning there. And so again, the takeaway here is to know that this is intentional. Treatment is intentional. Impact is unintentional. Excuse me. So disparate impacts involves unintentional discrimination. And so you look at rules, policies, they appear neutral, but they could result in a disproportionate impact on a particular group. So the example that I can think of is testing all applicants and using results from that test that will unintentionally eliminate certain minority applicants disproportionately. And so it's, maybe you didn't validate your assessment, but once it's been highlighted, now you have the opportunity to quit using it, because it's disproportionately, dispositioning candidates. And so again, treatments, intentional, impact, unintentional. And so Ayana, you're asking, isn't that assessed based on the number of employees in the company? So are you referring to like how we treat disparate treatment or disparate impact, or are you getting to the 4/5 rule? Because we're going to talk about that 4/5 or 80% here in just a moment. And we'll get into more about the EEOC and when they do come out to investigate and things like that. But I would say your middle to your larger organizations, yes. Now, when we get down to small business employers, it gets just a little bit more difficult because it's not on that larger scale, and so they don't have to necessarily abide by all of those rules and regulations that the EEOC has. I believe in Unit 1, you all talked about the different types of businesses, like your small mom and pop, your small businesses, and then your middle to your large employers. Let's see here. Brooke has a question. So I interviewed for an HR job and they explicitly told me they are not selecting me because I'm white and they're looking for a person of color. Just curious if that's technically okay to say. So they explicitly told you that I am shocked. That would not be a best practice. However, when we get into our AAP data, our underutilization data, if we have AAP programs that are more geared towards our good faith efforts, then we may have programs that are dedicated to certain minorities where we can identify underutilization within the organization. But to come out and explicitly tell someone that we're not hiring you based off of your race, I would never say something to that effect. Brooke here is like fair. That is the most direct response that I could probably take away from a recruiter. Yes, and actually it's interesting, Brooke, that you bring that up, because there's actually an example in the book here that speaks to AAP and EEOC, and I forget the example in its entirety, but we'll get to it. But it talks about a white male and an basically all I want to say Black school. I don't remember it, but we'll get to the example, and it talks about the AAP data and it not holding true if they don't necessarily have a program in place. And so just again, along the lines of Title VII, discriminatory practices, there's that racial harassment, right? So the Title VII, again, Civil Rights Act of 1964, and I apologize for having coughing spells throughout tonight's lesson. So this does protect employees against racial harassment. And you probably may have seen this in your handbook at work, but it goes against racial epithets, derogatory comments, verbal harassment, graffiti, racist jokes. And this is not an exhaustive list, but just note that employers are liable for the harassing conduct committed by supervisors, co-workers, customers, and clients by means of vicarious liability. And so basically vicarious liability is you knew about it and you didn't prevent it. You did not take any prevention approach to mitigating racial harassment in the workplace, right? Because we have training, right? We have all types of training. We have harassment training. We have sexual harassment training. We have violent prevention. So basically vicarious liability says, hey, you didn't do any of that and it happened on your premises. You are still held liable, even though you may not have known about it. So any form of derogatory speech, including humor or neutral words expressed in a hostile or intimidating way, can constitute racial harassment. And just like racial harassment, there is sex discrimination as well. So again, we are probably well versed in all of these harassment type situations because we get enough training with our current employer. And so sex discrimination just prohibits sex discrimination regarding any employment condition, again, unless there are those exceptions of those BFOQs that we talked about earlier in this section. And so sex discrimination is discrimination in employment opportunities against a person. And so this is typically a woman on the grounds of sex. And so an example would be a woman applies for a job as a sales executive or something up to that degree. And although this person or this woman has experience and excellent qualifications, the woman is not hired because some long-term clients are more comfortable dealing with men. And I've actually, early in career, I've actually had this happen to myself. I used to work in the tool department at Sears, and it was many moons ago. And I remember that just several men would not even entertain me in looking for tools, even though I was very knowledgeable. They did not want me in the tool department. They said that I did not belong there, and that they would seek out a male person to help them, even if the male was not even in the tool department. I could have been the only person in the tool department. So there is some sex discrimination again, and it could come in the form of the employer, customers, clients, anything to that degree. And again, an employer would have that vicarious liability because we need to be, well, and this was several years ago, but just inclusive in educating our business partners. But in this example, there is a term called the glass ceiling, and I believe we have a poll and it is coming up. And so let me see here. Glass ceiling. So many women experience subtle forms of discrimination that limit their career advancements. It is called the glass ceiling. It is to create that host of attitudinal and organizational barriers that prevent women from receiving that promotion information, training, encouragement, mentoring, and other opportunities they need to advance in the workplace. And so with that being said, I am going to advance to my next slide that has our questions, and I'm going to bring my poll over here, launch it. You all should see it. So the question is, the glass ceiling in a company refers to what? All right. Well, I love what I'm seeing. I love unanimous answers because that either tells me that I might be reading too fast, or I might be really spot on, or I may need to cover a little bit more information in detail. So let's go ahead, and it looks like, oh, I still have some people coming in. I'll give you just about 3 to 5 more seconds. Get your answers in. And let's see what we discovered. All right. So here we are with poll question number 2. Again, the question was, the glass ceiling in a company refers to what in an organization? And it just refers to that attitudinal and organizational barriers that prevent women from advancing. We like to call what, the good old boys club, right? Where only the guys get to go in golf. And that's when they get that great mentorship. And that's when they get those training opportunities, those additional educational opportunities, or, they're going out for drinks at the end of the day, or over the weekend, or anything to that degree. Those are the ones that are invited to like all the parties, the Christmas parties or whatnot. And so they do get to meet with the senior leaders quite a bit, and they get their name out there in the organization. And so it did hinder a lot of women from reaching their full potential because they were held back because of the good old boys club, right? And so that is where that term glass ceiling comes from, because we feel like we have hit the ceiling because we can no longer advance because of just some barriers within our organization. I am so happy to say that we are starting to turn that tide a little bit in advancing women to become CEOs and senior leaders. And I think that is just a wonderful thing that I am seeing. There was a quote that I read not too long ago that said that we will no longer have to say that we have female leaders. We will only be able to say that we have leaders within our organization. So looking forward to that with the continued advancements of women into those senior leader positions. All right, so let's see what we have up next. So next is the religious discrimination. And so here, when we talk about religious discrimination, it is where employers are not allowed to hire, promote, train, compensate, discipline, lay off, or terminate on the basis of an individual's religious beliefs or observances. And so if you think about the vaccine mandate, this is one of the accommodations that's coming under fire, which is the religious discrimination, because again, I'll reread it. So employers are not allowed to hire, promote, train, compensate, discipline, lay off, or terminate on the basis of an individual's religious beliefs or observances. And so the provision is intended to protect employees from any adverse employment decisions because of their religious beliefs and how they choose to observe them. And so again, if you've been following in the media and you've been reading more into that executive order that was put into place by President Biden, you'll have a better understanding of where we are with this vaccine mandate and the accommodation process. And it is very detailed, the religious discrimination I shouldn't say the religious discrimination, the religious accommodation form when it comes to being fully vaccinated. However, there is an example that is brought to us in our book, and it's coming back from 2015. And some of you all actually may remember this case, which went all the way to the Supreme Court. And it was the case of the Eeoc versus Abercrombie and Fitch, which focuses on whether applicants and employees must explicitly request accommodations. And so the case was brought by a female applicant who wore a hijab, scarf worn, out of devotion of the Muslim faith, who was rejected for employment because she did not fit the clothing company's look policy. And while the applicant never mentioned her religion or requested accommodation, the employer suspected she wore the scarf for religious reasons, yet chose not to hire her without discussing the need to accommodate. The court held that the employer engaged in religious discrimination when it suspected there was a need for an accommodation, yet failed to inquire further. So if you think about religious discrimination, and if you think about a religious accommodation when it comes to the vaccine, it's kind of unfolding like this case here. Do you ask for an accommodation? Do you assume there's an accommodation? So for here, this is on its face, right? I'm visually wearing a hijab to an interview out of respect of my Muslim faith. You can visually see that. You knew as an employer that I was a Muslim and that I would need a religious observance. I would need an accommodation. And because of that, you decided not to continue on with the recruiting process. You can, again, flipping that to the vaccine right now is that they have to interview. They have to be the person that gets to offer. And then at offer, then they can request a religious accommodation. And then it kind of goes through the legal aspect and they render a decision. But it does not happen in the recruiting process before someone gets to interview, before someone is selected for that position. We want that person to get selected so there is due process. So we want to make sure that, again, when we're talking about religious discrimination or religious accommodations, we want to make sure that one, that if it is visible, that we inquire as an employer, and then two, if it is not, such as the vaccine mandate, we do want to put some parameters around that as, again, how do you apply for accommodation? Most of that wording can be found a lot in our job descriptions these days. So the candidate does request any type of accommodation if necessary. So that case, again, was a fail. That case is where they failed to inquire further. The company was held liable for religious discrimination. The next case here is the one with TWA. And this one was back in 1974, and it was TWA versus Artisan. And so in this case, the employee claimed that TWA did not satisfactorily accommodate his need to observe a Saturday Sabbath. However, TWA did provide evidence showing that it made several attempts, including possible job reassignments, scheduled trades, but none of these alternatives were acceptable to the employee. And then the court did conclude that TWA did make reasonable efforts to accommodate the employee and establish 4 guiding principles for sufficient accommodation, which you see outlined here on the slide. And so, as you can see, you must not have to sacrifice the rights of other workers. So I cannot give you an accommodation if it's going to force my business to work, an additional day a week so you can have a day off. It cannot breach collective agreements. And so that is going for your union workforce. So if you have a collective bargaining agreement, it cannot breach any of what you have set forth in that agreement. It cannot suffer lost work efficiency, right? I need you in order to run my business. Maybe you are a small business employer and is going to create that undue hardship. And it cannot have any de minimis action as well. So you would, should not have to pay someone else for overtime in order to give someone an accommodation. So those are the 4 outliers there that would come under, you would have to have one of the 4 or more if necessary, if you are trying to plead your case. Oh, yeah, Shauna. So, yep, that is an interview question that is being asked. And you can absolutely refuse to disclose. And they can continue, and they should continue with the interviewing process. So if you were, again, if you went through the interviewing process and got to offer, then you could request for an accommodation with the employer not objecting themselves to any discriminatory practices. Now, the thing is that they dispositioned you. I'm assuming, I don't know why, but if it was because you disclosed that you refused to get vaccinated, or you refused to disclose that information, Then again, it becomes a slippery slope, because you do have to, if you wanted to file a case of this discriminatory practice, you would have to be the person that calls out the discriminatory on employment practice. And then again, the employer would rebuttal depending on the evidence at hand. So here we are talking about the EEOC. And so we're talking about these additional responsibilities as it relates to age, pregnancy, disabilities, and then genetic information. And so I just want you all to know that the EEOC does not have the same authority as other federal agencies to issue directly enforceable orders. Employers are required to provide the information the EEOC requests, which may require extensive time and substantial data collection and analysis. Again, everything is discoverable when EEOC gets involved. And they do answer numerous calls. They do get numerous inquiries. However, out of the numerous inquiries that they receive, there is a certain percentage that do receive benefits from the EEO resolution, but a lot of times it's just communication, right? Maybe it's education. Sometimes it's not always that monetary value. And so when we think about the EEOC complaints and procedures, how do we file a complaint? What happens after we file a complaint, or what happens after an employee files a complaint? And so when a discrimination is alleged, a written charge of discrimination may be made by or on behalf of any person claiming to be the aggrieved. And so the EEOC, it will conduct an investigation to determine whether they are legitimate. And then Title VII claim is 180 days. So they do have a statute of limitations. The employee does have up to 180 days to file the claim, or it can be extended by 300 days if there is any applicable state agency that also has a law prohibiting the same type of discrimination. So 180 days is pretty much the standard. And again, if it does come up on your exam likes numbers, they like dates. So 180 days would be the correct response there. So when we talk about mediation and litigation, so a charge has been filed. What happens next? There will be an attempt at a mediation and settlement. So again, it's all about communication. It's all about bringing your facts to the table and looking at those and rendering a decision. Again, sometimes it's education, sometimes we go a little bit further. So the EEOC, it may attempt to resolve the problem through a process called mediation, and that mediation refers to an informal out-of-court settlement between the employer and the charging party, and it has been proven to be an effective means of resolving many workplace disputes and avoiding the need for investigation. Fun fact, it does take about 10 months to resolve a charge through the investigative process. So this is not going to be an easy process for all parties involved. So almost a year sometimes, depending on what the charge is. And so as you can see here, that investigation does take place, and it can go either left or right. So the EEOC determines that there is no reasonable cause. At this point, the employee may request a right to sue letter, or on the right side of things, the EEOC determines that there is a reasonable cause and that they will issue a letter of determination to both parties. After that, they will attempt to resolve through conciliation. So again, kind of that mediation, conciliation, kind of going back and forth to see, what really is going on. We're preventing, sending facts. We're pleading our case. We have documents. They have come in that that we have had to surrender. So they're going to be asking, a flurry of questions from us. The EEOC is going to review the case for litigation. And then again, it can either go left or right. And so either it is going to recommend litigation and take legal action, or is going to dismiss it and recommends against litigation. And still at this point in time, the employee can issue that notice of right to sue. So if you've ever been involved in an EEOC claim, it is not for the weak. And so be prepared to be able to submit information really quickly. So again, you want to make sure that we document, and that's why we have personnel files now pretty much, or I shouldn't say pretty much, but of everyone within our organization. So when you are responding to an EEOC charge, you never want to ignore the charge. Again, you're going to preserve those relevant documents, avoid retaliation. I think educating our workforce on the avoidance of retaliation is going to be important, because we get excited, we get upset. And so we want to maintain confidentiality as much as we can. Prepare your position statements. How are you going? What is your plan on how you're going to respond back to the EEOC charge? And then take advantage of mediation when it is most appropriate. Again, a lot of these things is because there was a breakdown in communication somewhere, or maybe we can educate our workforce with some training, coaching, and providing feedback. So now we are advancing forward, and I'm doing a time check. So here we are at adverse impact in the 4/5 rule. And so here, the 4/5 rule is basically, again, like that 80%. And it is a selection rate for any race, sex, or ethnic group, which is less than 4/5 of the rate for the group, but the highest rates will be regarded as evidence of adverse impact. And so I am going to show you this next slide here, and then I will break into our YouTube video so you can see just from a video perspective how adverse impact is calculated. And I believe Chris does have some examples for us to use as we progress forward with the ending of tonight's lesson. So again, the 4/5 rule, or that 80% is the evidence of adverse impact, is represented with the percentage of any race or gender group passing the selection test is less than 4/5 of the highest group rate. And so here, for example, you have 133 of 179 white firefighters pass an exam. And so the example is actually coming directly from the book on page 18. And so they passed the exam at 74%. Well, the same group of applicants, so 38 of 89 were Black firefighters. And so their exam pass rate was 43%. So what you do is, you remember 4/5 is 80%, right? And so what you're going to do is take the higher amount of the past exam rate, which we know is to be 74%. You're going to times that by 80%, and that is how you're going to get your disparate impact, or your 4/5 rule. So that is going to be 59%. So anything less than 59% means that you have an issue. So you have some disparate impact, right? That unintentional impact on your recruitment process. So what you can do, again, you need to maybe go back and revalidate your assessment or stop using it. You do have some choices now that this has been highlighted. Because if not, what you're saying is that you are agreeing to this discriminatory practice. And so with that being said, I'm going to go ahead and let me see here. I might have to do a reshare. Oops, give me just a second. Let's see, I will do a new share, and all right, can you all see the YouTube video? Perfect. All right, so I am going to get this in play mode, and I'll have you all watch this quick video. We won't watch the entire thing. It's about 7 minutes long. I've already advanced it to where I want it to play, but I do want to have this person here, just from a visual perspective, walk through the 4/5 rule with us again so you can see it from a different perspective. I think.
Because of this, legal action can it adopts discrimination rules. The Equal Employment Opportunity and the courts have adopted a test known as the 4/5 rule to calculate adverse impact. This test compares the rates of selection for lesser represented classes of individuals against the rate at which the most represented group is selected. If the lesser represented group has a selection rate that is less than 4/5 or 80% of the selection rate for the most represented group, this can be used as evidence of discrimination or adverse impact being present. Again, a selection rate for a protected class group which is less than 4/5 or 80% of the rate for the group with the highest rate indicates adverse impact. So we must always ask the question, is the percentage of a lesser represented group equal to at least 80% of the percentage of the most represented group? If yes, no evidence of adverse impact exists. If no, evidence of adverse impact in fact exists. There are 5 steps to determining adverse impact using the 4/5 rule. Number 1, identify the policy or practice at issue. Number 2, calculate the rate of selection for each group. Number 3, note which group has the highest selection rate. Number 4, calculate adverse impact ratios. And number 5, use the test to determine if adverse impact exists. Let's take a look in detail. Number 1, identify the policy or practice at issue. To demonstrate adverse impact, a plaintiff, the employee, must show that a particular policy or practice on the part of the employer results in a certain amount of discrimination towards a protected group. Therefore, your first step should be to identify the selection requirement that is responsible for the differing rates of selection. By way of example, let's use a requirement that a police officer in a particular city must be able to lift 100 pounds to be selected for the job. 2. Calculate the rate of selection for each group. The next step in calculating adverse impact is to establish the selection rates for each group of individuals. This is done for each group by dividing the number of applicants selected for the employment process by the total number of applicants. The selection rates will then be compared in a later step. Returning to our example, let's say 100 men and 100 women applied to be police officers in our hypothetical city. 80 men and 60 women were selected for the position. So the selection rate for men would be 80%, or 80 divided by 100, and the selection rate for women would be 60%, or 60 divided by 100. Step 3. Note which group has the highest selection rate. In this step of the process, we determine which group has the highest rate of selection. The rate will be used as the point of comparison on which determination of adverse impact can be made. In our example, men have the highest selection rate for the police officer position at 80%. Step 4. Calculate adverse impact ratios. Once you have calculated the selection rates and determined the group with the highest rate, the next step is to determine the adverse impact ratio for each group. This is how each group's selection rate compares with the most represented group's rate of selection. This is done by comparing the selection rate for each group against that of the most represented group. In our example, we divide the selection rate for women by the selection rate for men, or 0.6 divided by 0.8, and arrive at an adverse impact ratio for female applicants of 75%. Finally, step 5. Determine if adverse impact exists. Once you have calculated the adverse impact ratios for each group, evaluate each adverse impact ratio using the 4/5 rule. This is the simple part. If the adverse impact ratio for a particular group is less than 80%, according to the 4/5 rule, this can be used as evidence of adverse action. Basically, this means that a member of the less represented group is selected for a position less than 80% of the time a member of the most represented group is selected for the same position. Returning to our example, the impact ratio for female applicants is 75%, which is less than 80%, meaning that the policy of requiring police officers to be able to lift at least 100 pounds seems to have an adverse impact on female applicants. To reinforce our understanding of the 4/5 rule, let's take a look at a different example. So here's another calculation of 4/5. In this scenario, we have 80 white applicants, of which 48 were hired. There were 40 black applicants, 12 of which were hired. The selection rate of white applicants is 48 divided by 80, or 0.6, which is 60%. White applicants are the group with the highest selection rate. The selection rate for black applicants is 12 divided by 40, or 0.3, which is 30%. The impact ratio then is 0.3 divided by 0.6, which equals 0.5, or 50%. The impact ratio of 50% is less than 80%, which is evidence based on the 4/5 rule that adverse impact exists. You can use this table and these simple steps to develop your own analysis of whether adverse impact exists in a disparate impact case.
The right care at the right times.
All right. So let me go back to our slide here. And Ayana, I thought so as well. So sometimes, the book breaks it down, but it doesn't give that granular detail when you think about adverse impact. And I think that it is so important to recognize how to cover or how to do the formula because you want to know, if your process is going to have any adverse impacts on a group of people. So again, kind of going back to Chris's example that he has here, which is great. And you'll have this content. You can go back and review the YouTube. I think even for me, a long time ago, trying to get an understanding of adverse impact in the 4/5 rule, that video really, really, really helped me outside of the context of the content in our book and really outside of anything else that I could find that was discoverable. I am doing a time check and I realized that we are a little bit over time. So Chris did pop this in here. You might want to look at it just via the playback and kind of see if you can do the numbers for yourself, knowing that you do have the example that he provided. You'll have the YouTube link to cover all of this information. And then he does have an exercise in here or a question that he would like for you all to answer. We won't get through that tonight, unfortunately, but the last thing that I do want us to do is, advance these slides. But the last thing I want us to do is answer the last question for tonight. And so according to the 4/5 rule, discrimination occurs when what happens? And I'll go ahead and launch that for you all to answer. All right, I see those responses rolling in. I love it. I'll give you all a few more seconds. I know it is late in the evening. I appreciate you all hanging in there with me as we wrap up our first session out of Unit 2. And so we will meet again on Thursday. Today is Tuesday. Wow. On Thursday. So we'll get back into Unit 2 starting on page 19. But let's see where we landed here in this poll. And so with this question here, I asked, according to the 4/5 rule, discrimination occurs when what happens? And so the correct answer here is D, as in David. And so D tells, get up there. And D tells us the selection rate for any minority group is less than 4/5 of the selection rate for the highest group. And so so there's two key words there. We're talking about 4/5 and we're talking about highest group. And so that is really what the 4/5 rule is referring to when we talk about discrimination. So the percentage of minorities in any ethnic or gender group is less than 4% of the percent in the surrounding labor force. And we're not necessarily concerned with the surrounding labor force. We are concerned with your recruiting practices as the employer. You selected A and you selected B, and based off of that, who had the highest selection rate, and you're going to divide that by that 0.8. And then B, it seems, I think some people identified with B, and it says less than 4/5 of the applicants in any minority group are accepted for employment in a job category. And again, we're just going through the recruitment process at this stage, right? We're going through the selection process. And so we really aren't classifying them in a particular job category where we could look at underutilization, we could look at some AAP data or even some EEO data, but that is not what the question is asking. And so one thing I do want to mention before I let you all go is when you are reading through your questions, make sure you're not looking for something that isn't there. So I always tell my learners, don't add your own narrative. What you see is what you get. There isn't going to be any more than that. So I know as HR professionals, we want the kit and the caboodle. Unfortunately, some of these questions aren't going to give it to you. So you're going to have to go based off of what is provided to you in order to make a decision on your 4 choices that you're going to have available. So be thinking about that as you are doing your pre-assessments in HRCP and as you are gearing up to take your exam at the end of this 16-week course here. So thank you all for sticking with me for a few extra minutes. Like I said, we will do this again on Thursday, and we will pick up on page 19. So everyone have a good evening. And with that being said, I will let you get back to your evening activities. You all are welcome. All right, good night.